let's move on to Baden Clay.
Mm.
So can you explain to us what circumstantial evidence is and how it was used in Baden Clay?
Let's talk about evidence and the law of evidence. When you watch TV shows or read books, you have lawyers standing up in court saying, "I object, that's inadmissible," and the judge says overruled or sustained, and the evidence is let in or not let in. And it sounds like this is a very strange thing that lawyers do in court that nobody else does anywhere else on earth. It's a weird thing that you won't allow the jury to hear something. Why not? Well, it's this. Consider that you are trying to decide whether something important, like it's hard to think of an example. All right, let's just think about little Billy probably broke the window because he probably threw the stone. He probably threw an object through the window and broke it, right? He probably did it. He's got a red face, he's sweaty, and his eyes are shifting all over the place when Mummy says, "Billy, did you break the window?" And Billy says, "No, I didn't. And his sister, Mary, who has just come home from visiting her friend, says, "I saw him do it." "Yes, he did. I saw him do it." And the mother says, "What did you see?" "I saw him throw a rock through the window." Now, let's just consider it. The mother goes and looks at the room in which the window is broken, and she finds Billy's cricket ball and no rock. Right? So she tries to figure out what happened. There's nobody else in the front yard that could have done it. The daughter was not there. She just come home. She wasn't there. And there was only Billy there, and the ball belongs to him, and it's got a little speck of glass on it. Now, nobody saw Billy throw it. The mother says, "I'm not going to pay any attention to what the sister says because she's prone to exaggerate and she's prone to always be nasty to her brother because they had a fight this morning. So, and anyway, she wasn't there. So I'm going to exclude that evidence, and I'm going to just look at the evidence I have." Billy was the only person in the yard. The ball was in the kitchen. It had no business being there unless it came through the window. Logically, it couldn't have come there except through the window. What's more, there's a piece of glass attached to it. It's Billy's ball, and I saw Billy in the yard before. The inference, the logical conclusion I draw from that evidence, not having seen anything myself, is that he threw the ball and broke the window. What I don't know is whether he did it deliberately or accidentally. None of the evidence suggests one or the other. Billy denies that he did it. That might suggest he denied he did it because he'll get into trouble because he did it deliberately. But on the other hand, he might deny that he did it because he's worried he'll get into trouble for breaking the window at all because he was careless. And so he might be worried about that. It's one or the other. I can't tell which. 50-50, could be either. So I can't conclude whether he did it deliberately or intentionally. And I can completely, and I can't rely upon Mary's evidence. I'll call it evidence now, because she's unreliable, because she wasn't there. And she said it was a stone, and there's no stone in the kitchen. So her evidence is completely unreliable. It doesn't bear upon the question. I exclude it. Right. So there you have the kind of thing that you decide every day one way or another by drawing inferences about what might have happened. The wife is at home, the husband comes in at 2 a.m, he's reeking of perfume and whiskey, and he's lost his tie, and he's drunk, and there's a lipstick stain on his collar. Well, call that evidence. She knows that he's been with another woman, and she puts it to him. And where have you been? I've been with Fred at his house. Well, she knows that's a lie. The fact that she knows it's a lie suggests that the evidence of her eyes is more likely true. The inference she's drawing is more likely true because he wouldn't lie. Otherwise, he could have said, if the truth was that his secretary kissed him goodbye, you know, and she's 80 years old and adores him like a mother does, you know. And she kissed him goodbye, and by some means lipstick got on his collar. If that was so, he would have said it, because he knows. But he didn't say it. Instead, he says he's with Bill, which is, could be true, but obviously not true, because a few more questions will show it. So you decide those sorts of issues all the time on serious things and not so serious things, based upon what you see and the logic that you construct around it that leads you to a conclusion. What we've discussed is circumstantial evidence. So the ball, the glass, the mother saw Billy in the yard, his presence in the yard. They are pieces of, they're facts, and they are circumstantial in that they surround the breaking of the window. They are not the breaking of the window. Direct evidence is I saw him break the window. Mary's would have been direct evidence if it was true, or could have been true. That's direct evidence. But circumstantial evidence is pieces of information, facts, which raise a conclusion that you can adopt or not adopt, because there might be contrary pieces of evidence. So the law of evidence, all of it, is based on that kind of logic. And it was created at a time when juries were hearing cases and when jurors were not necessarily educated. And so a judge had to make sure that the jury heard only evidence that could be used to support the case, and not evidence that might look like it supports a case one way or the other, but doesn't really, in that when you do this a lot, you penetrate down different levels, and as you penetrate down different levels, because that's what you've been doing for 30 years, you can see that this evidence is completely unreliable, so you put it to one side. You can't expect a jury to do that, so you do it ahead of time, and you don't trouble them with that evidence. So you say, I exclude that evidence. So in dealing with a case like Baden Clay, Mrs. Baden Clay disappeared. 2 weeks after her disappearance, she was found dead. Her body was found in the Brisbane River, about 12 kilometers from where she lived. By the time it was found, the body had decomposed to such an extent that if she had any superficial injuries of any kind, there's any bruising to the head or cuts, it wasn't visible because of the deterioration of the body. So the body was found. The husband said that he'd gone to bed early, she stayed up, and when he got up in the morning, she wasn't there, and she didn't come back. But she used to go for early morning walks, so he thought she was on an early morning walk, and then she didn't turn up. And he told police, and 2 weeks later they found the body. And but otherwise, he didn't know, how she might have died. She had periods of depression, he said, and doctors confirmed that she had periods of depression. She was on medication, so maybe she walked off, and maybe she jumped off the bridge. And that's what he said. Maybe, likely she walked off and jumped off the bridge and killed herself. So the prosecution began to look at, having no eyewitness except, well, there was no eyewitness according to the husband, Baden Clay. He said he went to bed, so he saw nothing. If he was the killer, he was an eyewitness, but there were no other eyewitnesses, so the prosecution and detectives had to look at what there was. So first, the doctors could find no natural cause from which Mrs. Baden Clay died. So she didn't die from a heart attack or anything of that kind. Secondly, if she had fallen off the bridge and killed herself that way, they would have expected to find fractures, and there were no fractures. Thirdly, she was on antidepressants, but there were no relevant drugs in her system that would suggest that drugs had an effect on her death. So she didn't commit suicide by drugs. She didn't accidentally overdose. Drugs did not kill her. So something else killed her. She didn't fall off the bridge. She didn't jump off the bridge. And she didn't die from natural causes. And the antidepressant drugs she was taking didn't kill her. And what's more, the psychiatrist who treated her said that she was not suicidal. So she didn't commit suicide. In all likelihood, these are just pieces of evidence, you understand. You have to see what the whole case is about before you can draw a conclusion. They then looked at the clothing she was wearing, and they found vegetable matter, leaves, inside her clothing, in her neck, around the neck area. And certain of the leaves belonged to the kinds of trees that grew in the Baden Clay backyard, but did not grow where she was found. So that's a piece of information that you can use somehow. Mr. Baden Clay said he went to bed at about 9 o'clock, and that his wife stayed up. His iPhone was taken, and it turns out that you can examine an iPhone and find out when it was last charged, when it was put on charge. And it was put on charge at about 1:30 in the morning, when he was asleep. So that's a piece of information. And he had 2 scratches on his face, horizontal, diagonal lines across his cheek. And he said that he'd scratched his face shaving. And every man who shaves can tell you what a scratch looks like when you cut yourself shaving. And these did not look like scratches from shaving. Experts were called to examine it, doctors, and the opinion of the doctors was that one of the scratches looked like a fingernail scratch across his cheek, and the second one could have been created by a shaving razor being dragged horizontally in a way that you don't drag your shaver when you use it. So that you have that piece of information. Now, with that information, you can say that's evidence. So you prove that, and that's evidence before the jury. She died from something that was not caused by falling off the bridge down into where she was found near the river. And she didn't drown. There was no liquid in her lungs, and if you drown, you inhale liquid. So she didn't drown. There were no natural causes, so something else killed her. The leafy stuff in her clothing suggests she may have been dragged across the front yard or the backyard where the trees were growing that dropped these leaves. That's unexplained. She wouldn't have done that herself. We went out inferring things. All we know is that these leaves that were at her house were found in her clothes. That's all we know, and we're pursuing the logic. You say, well, she wouldn't have dragged herself or rolled around in the grass. That's unlikely. It's possible, but it's unlikely. It's more likely that somebody dragged her. Who dragged her? Well, there's nobody that we can think of except the husband. The scratches on the face. Well, he might have been shaving in a very weird way, but that's unlikely because that just doesn't happen in experience. And we're told that one of them looks like it was caused by a fingernail. And I suppose if you drag a fingernail, you're dragging a hard object about half a centimeter wide across the skin, and it's going to leave a shallow little divot. So you can say that's like an object that is similar to a fingernail, and you can't think of anything else. And as for the other one, it can be caused by a blade. How would you explain that? Well, if he's aware of her scratch mark, then he would try to disguise it by calling it well, the first one definitely isn't a shaving thing if you accept the evidence. So it's not a shaver, it's a fingernail. Once you get the fingernail, you have a fight. Once you have a fight, the only person there is him. So now you're getting to the point where you think he killed her, although you don't know if it's intentional or not. And an unintentional killing is called manslaughter. An intentional killing, that is, the intention is when you kill, you don't have to premeditate it. If I intend to kill you in this moment, then I kill you, that's murder. A much more serious offense. It's one or the other. Once you decide that A killed B, and if there's no defense, that's either manslaughter or murder, depending on intent, then you have to consider intent. So you ask, what's the evidence of intent? Well, at the moment, we don't have any. It could have been that he was angry, she was angry, who knows? Men and women have angry arguments. Some of them become violent, and sometimes the man, too often, unfortunately, the man kills the woman. not necessarily intentionally. You hit her, she falls, she hits her head, she's dead. You didn't intend to. There you are. That could have happened. So you then next consider what else there is in the evidence. And he gave evidence. You don't have to give evidence if you're the defendant in a criminal trial, but he chose to give evidence. And he said, what I've told you, I went to bed at 9 and she wasn't there, and that's the end of that, and I cut myself shaving. That was the evidence he gave. At that point, all you know is that he probably killed her. Do you believe him when he says, I went to bed? And you look at the evidence of the telephone, you say, I don't believe him. And you ask, why would he lie? He would only lie if he was awake at 1:30 when that phone was charged. Therefore, he did not go to bed at 9. Therefore, he did not leave her there and not know what happened to her. Therefore, he knows what happened to her. Therefore, he got rid of the body. And if he got rid of the body, then he killed her. That's why he got rid of the body. If she died of a heart attack on the kitchen floor when he woke up in the morning, he would have called an ambulance or the police. So he didn't. Instead, he lies about it. And he lies about the scratch. Therefore, all that points towards a killing. Still don't have intent. So the next thing you learn is that he was having an affair with another woman. He promised the other, this is April that she died, she was killed. He promised this other woman that he would be, she said, you got to tell your wife, you got to tell your wife, you know, you say you love me and you got to leave her and come with me. He said, it's difficult, but I'm going to do it and I will be with you by 1 July. On the very next day of the night on which she was killed, there was a real estate conference on the Gold Coast, and Baden Clay and his wife worked in their real estate agency, and the woman with whom he was having an affair was also a real estate agent, known to both of them. And the woman he was having an affair with and his wife were both going to go to the conference the next day. So he was having an affair with another woman whom he promised he would join by 1 July, that he would leave his wife. They were both going to meet at the conference. And so you can see then that there might have been a motive, there might have been a reason why they could have had a violent argument on that night. But you then get to this. The Court of Appeal then said, well, there's no evidence of intent. There's evidence of that he killed her, namely, she didn't die from natural causes, not drugs, not suicide. She didn't jump off the bridge. She didn't drown. Therefore, somebody killed her. There's nobody who could have killed her. There's just no evidence. Not only is there no evidence, but there is no evidence that there was any evidence of anybody who might have wanted to kill her or did kill her. There's only him. He lies about being awake. He lies about the scratches. Unless you accept his story, then all the evidence points to a killing. You have one more thing. If he lied about killing her, if he lied about going to bed and the scratches, why did he lie? Only one reason, because he killed her. There couldn't be any other reason other than that he killed her. Now you've got the killing. And the Court of Appeal of Queensland decided that the jury could not have convicted of murder, should not have, because there was no evidence of intent. There was evidence of killing, so they set aside the guilty verdict of murder and substituted manslaughter, and they said that should have been the verdict. The prosecution appealed to the High Court, and in the High Court said, no, that's not right, there was evidence of intent. If you didn't have the affair, you wouldn't have evidence of intent. But the fact that he was having an affair with a woman he promised he would join meant that he had a motive to get rid of his wife. You can do it by leaving, you can do it by divorce, and you can also do it by killing. And when you have a man who has killed his wife, gets rid of the body, then lies about it, and is having an affair which would have provoked him to want to, in the moment of anger, let's say, kill his wife, you have evidence of intent. Now, there's the circumstantial evidence, right? So you have the leaves, the medical evidence, the scratches, the phone. There are other things as well. and the affair, and you've got evidence then of killing, because you can put it all together and say he killed her, and you've got the affair, which is evidence of motive, and then you can decide, I'm satisfied he killed her, but I'm not satisfied of intent, or you can find I'm satisfied of intent. It's up to you as a jury. The jury decided on intent, on the killing. And what's more, there was this added element. When you go into the witness box and swear to the truth, I swear this is the truth, and you don't say, I swear it's the truth, I accidentally killed her, well, the jury could not rationally conclude it was an accident, could it? When you deny accidentally killing her, you also deny killing her, which is false, right? But you deny accidentally killing her, it's pretty hard to find that it was an accident in the sense that unintentional killing is an accident. When you've got all the other guilty evidence of guilt and the motive. So the jury must have reasoned that way, and the High Court reinstituted the conviction for murder. So you can see then that when we speak about evidence, you can argue whether a fact that's proved, Billy was in the yard, is relevant, is relevant because it could help you reach a conclusion. That's what relevance means. That makes a conclusion more probable or less probable. It's relevant. You put all those together. Don't do them one by one. Don't look at them individually. Put them all together and see where they all drive. That's a very human approach to problem solving. And although the rules of evidence can get very, very detailed in particular, because over centuries, lawyers go deeper and deeper and deeper into the logic. And that sounds like over technicality, but it isn't. It's just deep logic. So it can get very complicated, but at the heart of it, it's a human process where you look at what's happened. You look at what you're satisfied happened. The ball is in the kitchen, there's a piece of glass on it. Billy was outside, it's his ball. You can be satisfied he broke the window. You can't be satisfied why he did it or how he did it. With Baden Clay, you've got all of these pieces of evidence. You can be satisfied that he killed her. Then that remains, should I be satisfied of intent? You've got all these facts that you found, the affair, the lies. Are you prepared to draw that conclusion or not? Well, 12 people said they were. So that's that. You might have come to a different view, but you can see how when you look at it simply, the law of evidence is just human thinking.
Wow, thank you for that explanation.